Now, in a legal saga spanning over 3 years, a battle royal unfolded between two giants of the Indian moisturizer market, Nivea and Pond's. The conflict, rife with debates over oil content, hydration and even the ownership of the color blue, reached its climax in 2021 when Beiersdorf AG, the parent company of Nivea creams, bought Hindustan Unilever Limited, which is the manufacturer of Pond's, to the Delhi High Court. Now, the parent company of Nivea has alleged that Pond's salespersons were engaging in unfair market practices by conducting biased comparisons between the two brands in malls across the national capital. They argued that Pond's was misleading consumers by presenting their super light gel as superior to Nivea's creme. This is, of course, the latest as far as we're tracking for you viewers is that Justice Anish Dayal of the High Court ruled in favor of Nivea, stating that the comparisons that were being drawn by Pond's were misleading and disparaging, causing irreversible prejudice to Nivea. Even the use of a blue tub by Pond's was deemed to be associating with Nivea's product. I'd like to go across to my colleague Brian. Brian, what exactly did Nivea in fact allege? There were claims that Pond's was basically bringing about its own product and another tub, blue colored tub without any label though, but similar to the color that is used by brand Nivea, and comparing it, contrasting it on the hands of consumers. Take our viewers through what exactly the case was about and what was the final ruling that was and the observances by the court.
Pia, sales representative would approach customers, apply Nivea cream on one hand and Pond's on another, and then invite the customers to look through a magnifying glass demonstration that Nivea's cream left more residue compared to Pond's in that super, light gel. And talking about the Beiersdorf AG, which sought a permanent injunction against Pond's, accusing them of trademark infringement, unfair trade practices, and even disagreement also, dilution also, and even damages. Now, talking about the controversy, yes, Pond's countered that they were using a generous blue tub without Nivea's branding, arguing that Nivea does not have exclusive rights to the color blue. And they have also, PR, rather maintained in that their comparison was factual, as Pond's cream was less sticky than the cream in the blue tub. And now even talking about Nivea's stand, PR, Nivea responded by arguing that Pond's was making an incorrect comparison between two different types of products. And even Nivea's products, a heavy cream with 25% fatty matter, was being compared to Pond's gel moisturizers with only 10% fatty matter. They further provided a tabulated comparison showing that Nivea Men Fresh Gel, which contains just 1.35% of fat content, would be more appropriate comparison to Pond's Super Tight Gel. Now, even in his very ruling, Justice Anish Dayal found the activities of the defendant misleading and disparaging rather towards Nivea, causing very irreversible harm to the plaintiff. He also stated that Pond's action, whether explicitly or rather implicitly, were unfairly comparing their products to the Nivea's, leading to the customer deception. And now, regarding the use of the color blue, also, Pia, the court has dismissed, HUL's argument, concluding that using a blue tub in the exact distinctive shade used by Nivea was likely intended to make consumers associate Pond's product with Nivea's, and as a result of that, Pond's sale representative has also must have used a different color for the blue tub to avoid this very association, Pia.
Indeed, and finally the court has restrained Hindustan Unilever Limited from engaging in marketing or advertising activity of comparing its Pond's product with that of Nivea products, either expressly or by implication or association, especially through sale representatives. But also joining us this morning is Advocate Khushbu Jain, who is a Supreme Court lawyer, as well as Sri Ram Khanna, who is a consumer affairs expert. I'd like to pose my very first question to Advocate Jain. You must be familiar with the arguments that were made, but what does this mean? What are the implications for other giants, especially when it comes to marketing? their products and to ensure that such unfair market practices and especially infringement of trademark is not done?
See, when you talk about unfair trade practice, it's the laws have been very clear that whenever we used to see in the past that how one product which looks similar to one product which comes in the market with a similar product, just to get an advantage or to get an over advantage over the other product, they would make some additional changes to it or bring in and then compare it with the old product. Now with that old product belonging to somebody else, it's very clear that we are aware about similar thing happened with the Colgate in the past. So we see that Nivea, the color is very distinctive. The blue color we have seen from so long, they have not changed their color. So by our eyes, naked eyes, we would absolutely believe that this is Nivea. We don't have to go on reading the names also. So much money has been spent by people, by these industries in the marketing, in making their brands. And when these brands are made, we practically don't have to go and look into the spelling or to look into the name also, because by default, our eyes recognize that this is this or this brand is, this product which I see is belonging to this. They have been so deceptive. So unique. So in this regard, it has been very clear, and it's for everybody in the market today. This has happened to Nivea. Imagine the same thing happens with the Ponds tomorrow, that somebody new comes in the market and does the same thing with the Ponds. So these are unfair trade practice, and these have been recognized as illegal in India, and not just in India but everywhere else. And it's been considered that for a free market or for a market to have fair competition and to have that in place, we need to make sure that we don't go on deceptive, we don't go on utilizing such kind of tactics which are not fair, and adhere to such kind of practices which in a way go on misleading or false misleading or go on disparaging or cause some irreparable loss to the other company. So this has been very clearly been a stand which has been going on. The laws are there in place. The only thing that comes is with the fact that how much you can, with the facts you can believe that, okay, this is unique or this is not unique or this was deceptive. That's where I think the whole game plan is going on. But with law, it's been very clear. And by understanding also, I think everybody should adhere to such ethics and practices, that you don't go on taking such stances when it comes to fair market and fair competition.
Indeed, and speaking of fair competition, it almost is as if both of these companies have a duopoly of the market. These are, of course, two titans in the Indian market. As far as the example that you've given about another company foraying into this market, it might not happen in the near future, but even if it comes to other such industries, do you think now this case will set a precedent?
No, there have been always law. The precedents is already there. There have been a lot of judgments which have been there in the past. So when you talk about precedent, we already have precedents in place. We have laws in place. But this might be something which the two industries are being so strong and so much been spoken about. So this might be added in those list of precedents which have been landmark judgments which have been there when it comes to unfair trade practices being followed by the industry norms. So this is not the first. This is one of the incidents or cases that would be added in the scenario. But if you'll see, there are a lot of uniqueness that has come in this judgment when it comes to whether the color, specific color, do you hold ownership to the color or can you have a trademark over the color? So that's where I think the judgment is coming. So there are a lot of aspects of the judgment which are unique and which are new, which might come up as a precedent for the future cases to come in.
All right, I'd also like to take this conversation forward to Mr. Sriram Khanna, who's a consumer affairs expert. So thank you for joining us on the broadcast this morning. One thing that the court has in fact observed is that Ponds was prima facie misleading and disparaging the plaintiff, that is Nivea. And this is causing irreversible prejudice to the plaintiff. As far as what Advocate Jain was saying, it is the trademark color of Nivea that is recognizable. And what do you think can be done to undo this? Because consumers at the end of the day will not be scanning through the list or observing very keenly what they're being showcased. They are very likely to take what salespersons are saying at face value. So what can be done at the end of consumers as well?
See, madam, I have a completely different point of view on this from the consumer point of view. This is a battle between two commercial interests who are trying to muscle their way into selling more numbers of their cream bottles and making more money. And they have employed lawyers on both sides to prove that they are right. And the judge is listening only to them and then giving a judgment without having any reference to the scientific proof behind claims. This judgment is not based on any scientific evidence. If there is some residue in a particular brand, there should be comparative testing and the two brands should be compared. Which one has more residue? There are scientific methods. In fact, there is an ISO guideline on comparative testing of products. There is a national guideline on how do you compare identical products. In this case, I'm afraid in this rat race of making money, the truth gets lost. The consumers don't get to know which brand has more residue as tested in a laboratory. Neither brand will give it out. Neither the court has ordered testing. So I'm afraid such litigation is of no use for consumers. Of course, one brand scores brownie points. Their lawyers make more money as compared to the lawyers who lost. So it's about making money. It's not about the truth. So I object to the methodology used by this judge. And if somebody has the balls, they should challenge the judgment on the basis of scientific evidence. Where is the evidence? Without evidence, if courts are going to give their determination on what one party feels or the other feels, then I think it's not a good way to deliver justice in our country. Only the truth is sacrosanct, nothing else. And in this case, the truth is the casualty. We don't know which brand has more residue as a result of this judgment. Thank you.
All right.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.